5 seconds to go. Start. Absent any of these parameters, the court has refused to exercise writ jurisdiction. Even in jurisdictions where socio-economic rights have been elevated in status to that of constitutional rights, the enforcement of those rights were made available only against the state and not against private actors as held by this court. On the issue of potential conflict of rights, it is important to bear in mind the distinction between constitutional rights and constitutional values. On a formal level, values are understood teleologically as things to be promoted or maximized. Rights, on the other hand, are not to be promoted but rather to be respected. It would not show proper concern for a right to allow the violation of one right in order to prevent the violation of other rights. This would promote the non violation of rights, but it would not respect rights. Instead of values whose satisfaction is to be maximized, rights act as constraints on the actions of the state. They confer individuals with a sphere of liberty that is inviolable. Rights thereby act as restrictions on the government on how to pursue values, including constitutional values. It is therefore crucially important that we draw a distinction between the constitutional rights and constitutional values. Not every increase in liberty or every improvement in leading a dignified life is a constitutional right. This position has been accepted by this court. As held by this court in Justice K.S. Putaswamy, the court will strike a balance wherever a conflict between two sets of fundamental rights is projected. Strictly speaking, what is actually conceived by some and noted in several decisions, including Justice K.S. Putaswamy, is not the conflict of rights in abstractum at a doctrine level, but the conflict in the notion, invocation, practice of rights. On the issue of statements made by ministers and collective responsibility, a reference has to be made to Articles 75.3 and 164.2. Both these articles speak of collective responsibility of the Council of Ministers, though the language employed in these articles indicate that such a collective responsibility is to the House of the People, Legislative Assembly. It is actually a responsibility to the people at large, since every utterance by a minister will have a direct bearing on the policy of the government. There is an imperative need for a voluntary code of conduct. As pointed out by this court in Common Cause, supra, collective responsibility has two meanings, namely that all members of the Council of Ministers are unanimous in support of its policies and exhibit such unanimity in public, and that they are personally and morally responsible for its success and failure. Individual aberrations on the part of ministers are serious threats to constitutional governance, and as such, the head of the Council of Ministers has a duty to ensure that such breaches do not happen. A code of conduct to self regulate the speeches and actions of ministers is constitutionally justifiable, and this court can definitely examine its requirement. Ideally, a minister is not supposed to breach his collective responsibility towards the cabinet and the legislature, and hence it is advisable to have a cogent code of conduct as occurring in advanced democracies. When it is not possible to impose additional restrictions on the freedom of speech, it is certainly desirable to have a code of conduct for public functionaries as followed in other jurisdictions. The court may keep in mind the fact that this court in Sahara India Real Estate Corporation Limited Supra cautioned against framing guidelines across the board to restrict the freedom of press. Article 19.2 on the ground of vagueness and not providing manageable standards and clear guidance for citizens, authorities, and courts for drawing a precise line between allowable and forbidden speech, expression, or information. When a law uses vague expressions capable of misuse or abuse without providing notice to persons of common intelligence to guess their meaning. It leaves them in a boundless sea of uncertainty, conferring wide, unfettered powers on authorities to curtail freedom of speech and expression arbitrarily. The present case, however, are not really concerned with restrictions on the right to freedom of speech being imposed by the state. These cases are concerned with the content of Article 19(1)(a) of the Constitution, inasmuch as the grievance ought to be ventilated by the petitioners is whether there could be an inherent constitutional restriction on freedom of speech and expression on the citizens vis-a-vis other citizens. These cases are not with regard to reasonable restrictions that could be imposed by the state on the freedom of speech and expression, rather, what would be the content of free speech that should not be exercised as a right by an individual citizen, which would not in any way give rise to a cause of action to another citizen to seek a remedy. Stop.